Welcome.
Good afternoon, Chairman Hardin and members of the Health and Human Services Committee. I'm Megan Hunt, MEGAN-HUNT, and I represent District 8 in the northern part of Midtown Omaha. This bill is the next phase in a long-term project my office began several years ago with an interim study, LR 198, back in 2021, to examine the state's practice of intercepting Social Security benefits intended for foster children. I learned about this from a national investigation from the Marshall Project and NPR. Literally, colleagues, I was driving into work here to Lincoln from Omaha, heard a bit about it on NPR, and I became fascinated. I became really curious. And the study revealed that a majority of states were quietly using states' wards' Social Security benefits to pay for the cost of their care. So my office and I got curious, is this happening in Nebraska? Yes, it is. What these states have been doing is identifying children in their care, foster youth, who might be eligible for Social Security funds, applying for money on their behalf, and then keeping the money and using it to pay for the cost of their care. These are kids who can be eligible for Social Security money, averaging somewhere around $700 to $800 a month, for two reasons. One, because they have a parent that's died, or two, because they have a disability. So this is a group of some of the most vulnerable of the vulnerable children in our state. State child welfare agencies, DHHS here in Nebraska, have mostly contracted with private companies, and in Nebraska we use a company called Maximus, to screen kids for Social Security benefit eligibility and to apply to become the child's, quote, representative payee. This is permitted by federal law, and the state's ability to retain Social Security assets of children in their care has been upheld by the Supreme Court. Per federal law and Social Security regulations, minor children cannot serve as their own payee or receive the benefit money directly because they are legally recognized as not capable of responsibly managing the funds on their own. So the kids that are eligible have to have a representative payee manage the money and an account for them, whether that's a parent, another relative or guardian, or the state. So in most cases in Nebraska, the state becomes the representative payee, and all the kids' money goes to the state. And then the state uses that Social Security money to reimburse itself for the cost of the kids' care. There's a lot wrong with this. The overarching problem I see with this is that foster kids should not be funding their own care. They should not be seen as a revenue stream to the state to fulfill their obligations to these kids. But at a more pragmatic level, whether or not we think any of the kids' money should be kept by the state, we could all agree that if the state is going to do this, intercept money from vulnerable children, at a minimum, they need to do that making sure those kids have full knowledge, full consent, full transparency, communication with the children and their legal representatives and their parents or guardians. This is just a government transparency issue. And I think that if this was happening to any other group by any state agency, people would be making a much bigger deal about it. People would be up in arms about it. But due to the nature of this practice, that the affected population is vulnerable and disabled kids, the families might not necessarily realize that this is going on. So once I learned this was happening, we started working on various types of legislation to shine a light on the practice and then try to get some of those money back to the kids who are entitled to it. The interim study that we did in 2021 revealed that this was indeed happening in Nebraska to something like 400 kids a month, generating nearly $3 million a year for the state. I used the findings from that study and extensive collaboration with stakeholders to bring LB275 in 2022, and we got a portion of that bill passed in the Health and Human Services Committee Bill 1173 that year. And what it did was require the Department of Health and Human Services to notify youth and their guardian ad litems if they were benefit eligible and if the state was going to serve as a payee and retain their funds, and to keep a regular accounting of the youth's assets. So the bill got really watered down, but it did get passed in that form in a committee bill. This was an important step forward, and we wanted to see it take effect and watch for a couple years to see what other kind of action could be needed. I've been working with child welfare advocates on the language in this bill to bring it up to speed with changes and progress that other states have made since we advanced our bill to bring more transparency, fairness, and opportunities for engagement in the process for foster youth with their guardians and attorneys. What this bill does, in summary, It strengthens department communication with youth and their guardians about eligibility screening for Social Security, its application to serve as the child's representative payee, any benefit determinations, and the right to appeal or request a different representative payee. It requires the department to hold the youth's benefit funds in a trust account separate from the department's funds, and provide that the youth may request access to the funds for personal use, or that funds be used or conserved in a specific manner. It improves access to more detailed accounting information about the funds for the youth, courts, guardians, and youth's attorneys. It requires that funds are used in the child's best interest only when other funding is not available and are conserved for the child's reasonably foreseeable future needs. It requires the department to conserve a minimum amount of funds beginning at 40% when the child is 14, increasing at a sliding scale percentage as the child grows older. And it ensures that the child is informed about the process to receive and manage their Social Security benefits as they prepare to exit state care. Of these provisions, one of the most important to me is that we save at least some portion of these funds for the kids. If I had it my way, I would say that all the funds should be set aside for them. But I think what we have here, it's a compromise that we came to in consultation with national child welfare advocates, and that kind of brings Nebraska in alignment with other states' laws. When a child turns 14, that's the age at which the department starts working with youth on their plan to transition into adulthood in regard to finances, and that's in Nebraska state statute. So in theory, this is when a youth gets to gain some education and some sense of autonomy regarding their financial planning, and that's when the state would have to start conserving a minimum amount of funds at 40% when they turn 14. My intent here is to take some steps toward being better stewards of our vulnerable state wards and their assets by involving them and their adults in this process, giving them rights to information about what's happening to their money and how to provide input on how it's spent, and to save a portion of it for the youth's future that could be used for college or technical education or a car or rent for their first apartment, whatever they might need. For youth in foster care, this money matters a lot. Many exit the system to lead successful lives, but they are also more likely to face challenges like increased rates of homelessness, substance addiction, increased healthcare needs, and difficulty finding work. There's all kinds of data about how youth aging out of the foster care system without permanent families are more likely to experience homelessness, unemployment, and incarceration. With LB275, the legislature can help better prepare these youth for transitions to independence. In closing, I'd like to emphasize that child welfare agencies exist to protect and serve the interest of vulnerable kids. Federal law already requires that states pay for the cost of foster care, not the children. By intercepting foster youth Social Security benefits, the state of Nebraska is forcing abused and neglected youth to self-fund their own care. We all know that that's not right. Foster children should not be used as a funding source for their own care, and this bill just provides more transparency around how the state does that. Thank you.
Questions? Senator Hansen.
Thank you. You mentioned earlier about the Supreme Court upheld the decision, giving the state's rights ability to use this money or take it, right, correct? So
Yeah.
Would there be any issue with this bill and that decision?
Nope.
None? Okay. Just want to get your opinion. Thanks.
No. The Supreme Court ruling was in 2003. It was Washington versus Keffler, and it found that agencies did not violate the Social Security Act by using foster children's benefits to subsidize their care, but the ruling left room for states to successfully challenge it, and for due process and the kids' rights to be treated equally to other foster children who aren't being required to pay for their care.
Right. Thanks.
Also, a lot of other states already do this.
Okay.
Do we have a sense, it says in the fiscal note here, the amount's about $3.5 million annually. And you were talking, it says $2,000 per child versus $1,000 per child. Do we have a sense in terms of just what it is the state is hanging on to per child?
I'm not sure per child. It affects about 400 kids per year, and so I would just do that mental math real quick. But
about 400 kids into $3.5 million. Okay.
That's how much they're pulling in from these kids' Social Security benefits they're getting because they're disabled or their parents died.
I see. Okay. Senator Quick.
Yeah, and thank you, Sheriff. Maybe you already addressed this, but what happens to the money? I mean, what do they do with the money if it's not if it's not spent on the kids, and they just keep it, or what do they do with it, for those dollars?
I don't know, I'm thinking about that. I've been working on this for so many years. I don't remember, Senator Quick, but I'll get back to you on my closing.
Okay. all
Thank
right,
you. Or maybe someone will address it, but I'll make sure too, if no one
Okay,
does.
all right, thank you.
Short math on that's about 8,750 per child. So, questions? Will you stick around?
Yes,
Okay.
thank you.
Proponents.
Thanks for your attention too.
LB275.